Hello, my friends. Let me talk today about this immunity um, case that was looked at by the Supreme Court this week. They had oral argument, and it was very interesting if you're wonky about it like me, but there's a lot of details, and so I thought I'd summarize it for people. So basically, what we have here is this relates to the special counsel's prosecution of Donald Trump in connection with January 6th. As I posted in prior videos, there's basically four counts involved. There's a conspiracy count, which basically the government always adds conspiracy, and in this case, it helps add more time onto him if he's convicted. There's two counts that have to do with obstructing an official proceeding, which, as I pointed out in the discussion of the Fisher case, which the Supreme Court heard oral argument on earlier, a couple weeks ago, it looks like those are going to be thrown out because the statute that in question was intended for the destruction of documents, etc., in connection with a judicial proceeding, not Congress. And finally, there is the conspiracy to deprive people of their rights to have their votes counted. That may survive. But Donald Trump had claimed that he had immunity from prosecution for any acts he took as president. And the district court said, no, you don't. Then it went up to the Court of Appeals for the District of Columbia Circuit, which is a body that where you go to appeals when you have a case in Washington, D.C. And in my experience, the D.C. Circuit is pretty much political, and they're really not guided that much by the law or facts. If there's a political element, there's one way they go, and that is toward the left. But be it as may, the Court of Appeal in D.C. basically, in my opinion, their legal opinion denying Trump's immunity claim is a piece of junk. Basically, they have two arguments. One is that, well, Trump can be prosecuted because he is prosecuted. Really, that's seriously what their main argument is. And in the oral argument earlier this week, Justice Roberts basically ripped that to shreds, and I think that was pretty obvious. The other argument they make is basis for their decision saying that Trump doesn't have immunity is that they say, look, we have so many safeguards in our system. First of all, we have to, before someone's indicted, the grand jury has to indict them, and the grand juries are always ethical and always very careful not to indict people. And that's that's a laughable assertion because, as is commonly known, you can indict a ham sandwich. That's what's said. In a grand jury proceeding, the defendant doesn't even have to know about it. They don't have a right to be there, and the prosecution presents a very one-sided argument. The second thing that the Court of Appeal said was, well, the Justice Department attorneys, they're very ethical, and they're subject to ethical standards, so we don't have to worry. We can trust them because they never bring selective prosecution. They never bring political prosecutions. Of course, the Supreme Court, the justices, not the ones that dealt with that, they basically they didn't have much respect for that argument. And I'll have to note that Jack Smith does have a record of there was a case where he prosecuted a individual who was the former governor of what state? What's his name? O'Donnell or something. Sorry, I don't remember the name. Bob McDonnell, the former governor of Virginia, and basically really overexpanded an interpretation of the federal bribery statute, and the Supreme Court unanimously threw that conviction out. And it's kind of similar what's happening here with this January 6th case is Jack Smith is blowing up the criminal statutes beyond what they were meant to be. Okay, so there we are. So it gets to the Supreme Court, and the Supreme Court, we have, of course, we have three justices who are on the liberal side, the three ladies, and then we have six justices, which more or less people call the conservative side, and pretty much, it came down to this, because we have the two sides came down with polar opposite arguments. Again, the government's position is yes, there is some immunity for presidents, but the court doesn't have to go make any decision here because there's protections built in the system. We don't selectively prosecute people because we're so ethical and upstanding, and there's safeguards. And Trump's attorneys made a very expansive interpretation of presidential immunity. What they said, the Trump's position is based in part upon existing precedent, which I'll get into, and also upon some statements in the Federalist Papers. Okay, so what are the Federalist Papers? You may not know. After the Constitution was drafted, it had to be ratified by a majority of or was it 9 out of the 13 states? Excuse me, because I don't know that off the top of my head. And people were reluctant. Before that, we had the Articles of Confederation, which gave very limited powers to the federal government. They were so limited that they couldn't function. And so people were leery of giving more powers to the government, and as a result, Alexander Hamilton, John Jay, and James Madison wrote anonymously what's a series of pamphlets we called the Federalist Papers. And Hamilton wrote 4 of them, and in these 4, among others, in these 4 papers, he basically said, look, I know there's that light turning off, saving energy. I guess you can see me anyway. Hamilton says, look, you're worried about the president becoming too powerful. But he said, these are in all 4, he makes the basic same argument. Unlike a king, if he does something wrong, he's the absolute monarch, you can't prosecute him. But he says, if a president breaks a law, we have a remedy. First we can impeach him in the House, then we can try him in the Senate, and if he's guilty, then he can be prosecuted criminally. Okay? So although it's not conclusive, that's pretty strong evidence that's what the founders thought were the president's, protections or immunities. Now, that makes that argument made members of the court a little nervous. There's the examples. What if Trump ordered SEAL Team 6 to kill his political rival? Well, apart from there's a lot of ridiculous hypotheticals. Okay, so now we have. Let's look at there's a famous case, Nixon v. Fitzgerald. And basically, what this case, I'm going to pull this up here, look at it here. Okay. So what Nixon v. Fitzgerald is there's a guy who's an Air Force officer, and he was laid off, and so he sued Richard Nixon personally for being fired. And the court basically said that, no, you can't sue a president for the actions taken within the outer limits of his office, acting as his office. And of course, the court was careful to say it's limited to civil proceedings. Now we have our light back on. But basically said, and they use the term outer limits, of the president acting in his official capacity. This case here with Jack Smith is a criminal case, but I don't really see what difference there would be. So So you have that, which majority of the justices in the oral argument seem to think, well, we need to resolve this issue. We're not going to buy the absolute immunity from Trump. We're not going to buy trust us. We're not going to prosecute someone wrongly from the government. They want to have some delimiting thing, and they talked about remanding the case. What basically, and that's probably the most likely thing that's going to happen. They're probably going to say, kind of follow the Nixon versus Fitzgerald case and say, well, if there's something that Trump did as an official capacity, and then he has immunity. But if not, then you can go forward. And it probably is a little more complicated than that because it's so hard to determine what is official capacity. And what the government is arguing when that brought up is they say motives. All right. Motive can ruin everything. So let's say, example was given when Barack Obama was president. He ordered a drone strike on this Islamic cleric who was also an American citizen and killed him. And in a subsequent strike intended for somebody else, he killed the guy's son who was also an American citizen. And so the question is, well, did Barack Obama commit murder? Can he be prosecuted for that? And so, the idea, generally, the consensus is, I know that's redundant, sorry, is that because Obama was doing this as part of his duties as president, he can't be prosecuted for that. But what the government wants to say is, well, what if you're doing something that's totally official, but your motive is bad? For example, let's say Barack Obama had a personal vendetta against this guy that he had blown up with a drone, and the guy owed him money or something, or slighted him, or called him a racial epithet. Well, that would destroy the immunity there that Obama had because he had a bad motive. That's, the justices seem to be a little leery of that. I'm talking to the 6 conservative ones because the 3 liberal ones really, they weren't that. They threw up some objections and some questioning, but they weren't as firm on it as others. So what's most likely to happen is they're going to remand it. That means they're going to send it back to the district court with instructions and say, you have to determine this, you have to determine this, these are the guidelines you have to use. And this is the justices seem, although, the government tried to bring it down to let's decide this particular case and these issues, the government, several of the justices, they took the position, no, this is an important thing, we want to resolve this issue, not just for this case, but for a long time. So they're going to probably try to craft something within the Nixon v. Fitzgerald precedent. And when is an official act? When does the president do an official act? Is his motivation important? And so this is going to be very interesting. Now, as an aside, some of the commentators have said, well, this obviously is favoring Trump because if it's remanded, then that means it's going to take more time for the district court to decide things, and that's going to delay trial beyond the election. Well, that kind of points to the fact that this is a politically motivated prosecution. Notwithstanding, one could say, well, the voters ought to be able to know whether someone violated the law or not. Well, this is kind of a close case. It's not like there's no question about the facts of what Trump actually did. The facts are there. It's not whether we're trying to figure out did he shoot the guy? Was he actually there? Did he have a gun? So, in my opinion, the voters can figure this stuff out themselves. We ought to let it, in the absence of any, if we ought to give the benefit of the doubt so as to give voters the chance, to voice their opinion on that. Anyway, So this is a very, very interesting case. It's fascinating. I listened to the whole 2.5 hours or whatever oral argument. The judges were very well prepared. I was very impressed with them. Very well thought out, most of them. A couple more kind of weak. I don't want to say anything about certain justices, but this is an important issue, and I hope it gets resolved. Thanks.